Stay hydrated. All right. Dan, drop. Hi, Gordon.
Bye. Thanks for your help. All right. Let's turn to my forever friend, FPC deed.
Your Honor, there was supposed to be a court reporter. I don't see one though.
Well, it's on you guys. That's how that works.
Was attempting to log in earlier.
Okay, I think, yeah, she attempted to log in earlier because the time got changed. Can you give me 1 second to see if I can try?
Sure.
We're calling her right now, Judge. I think she's in the waiting room. I don't know. I think that was.
We don't have a waiting room. So, and it's my bad that we are starting late, but we had a more active criminal calendar this morning than I thought. So we had one last plea that spilled over past 1 o'clock. So I apologize. That made you all wait around. But Ms. Niles, hopefully let you all know, and we will get started once the court reporter joins us.
Yep, no problem, Your Honor.
Oh, hell no. You gotta look up the code.
Yeah, I don't know.
We're trying to get it right. Everybody ready? Go.
You gonna go or no?
No, he goes there.
I'm to my late.
Should.
So 1 month delay in the elevator policy.
Okay,
That was the right call?
very convincing.
I don't know. I said, just 1 month so that people can have conversations about it. We did a bad job of spreading the word. And so yesterday was that firestorm. So this way people can be heard, and it may well be that the exact policy is what goes in, but there'll have been a discussion.
That's what I'm used to, you know, but I don't.
Stay out of the way.
Mm-hmm.
About the others.
Yeah. Oh, yeah, yeah.
That's what I'm talking about. Picture that. Remember we went there?
Mhm. You know, who you going
Yeah.
to? Email those.
Right, so what you trying to do? I'm calling. Yeah. Oh, man, wait, you. You want to do it, go ahead, yeah. Okay, son. I said right now.
Mr. Huffman, any update from this court reporter?
Yeah, I think she had the wrong link because it was the older link, so we've just provided it to her, so she.
Okay.
I said, just sewer. That's too bad.
Looks like somebody just joined us here.
Yes, Ms. Brooks. Hey, Ms. Brooks, can you hear us?
Yes, sorry about that. Was having some trouble getting on there. Apologize. I didn't know I needed a new link. But
No
I'm here.
problem. All right, so you can hear us and you're ready to go forward.
I am. I just need to know who the parties are representing.
Well, I'll get all that on the record. I just want to make sure you're ready to start taking stuff down.
I am. Go ahead.
Great. Okay. Let me do this. This is 24cv012485. And the plaintiff in this case is FPC Deed LLC. And for purposes of this hearing, who is representing FPC Deed?
I am, Your Honor, John David Huffman.
So we've got Huffman for FPC Deed, and they have sued Kronos Resources and Mr. Smith as one group of defendants. And I believe, Mr. Roble, you are on for Kronos and Mr. Smith?
That is correct. Good afternoon, Your Honor.
Good afternoon. And then the other set of defendants would be the Clark Law Group and Mr. Clark. And I believe, Mr. Davis, you are on for those two defendants.
You're correct, Your Honor.
Excellent. I'm on a tear. So we are here to discuss motions to dismiss that were filed by all the defendants, but it's two motions to dismiss, one from Mr. Roble and his firm and one from Mr. Davis and his firm. They overlap a fair amount. They're not identical, but they overlap a fair amount. And we need to work through that today. In getting ready for the session, I came to appreciate more what this suit is about. I had assumed mistakenly that the alleged fraud and deception and trickery and whatnot had to do with representing that Unit 5F was actually an occupiable ownable, I guess ownable is the wrong word because someone owns it, but occupiable condominium unit at Springside Park, which we all know it is not. And saying that it is would certainly be fraudulent and deceptive, but that's not the alleged fraud in FPC Deed's complaint here. The fraud is and the conspiracy, et cetera, is an alleged set of transactions between Smith and Clark or corporate entities on whose behalf they acted to create a scenario where it appeared that ISBC, not a named defendant here, actually had redeemed its super priority lien and was in a position to foreclose on that and thus create a foreclosure sale at which FPC purchased Unit 5F. And that's a more sophisticated alleged fraud and helps me better understand when statute of limitations might have started running, et cetera, et cetera. Before we dive into the specifics of each of the three sides' arguments, Mr. Huffman, I don't want in any way to be misstating, overstating, understating what your complaint is all about. Is that a fair-ish summary?
Fair-ish, yes.
Okay, I'll take fair-ish. Then before we dive into any of the substance, I want to make sure that we still are traveling as motions to dismiss a number of the arguments that Mr. Huffman makes opposing dismissal. A number of those arguments rely on information taken from Mr. Smith's deposition, which couldn't have been part of the complaint. So I'm wondering if there was at one point in either Mr. Davis or Mr. Roble, or maybe both, their responses to FPC's position, like, wait a minute, that's turning this into a motion for summary judgment if you're going to rely on something outside the four corners of the pleadings. And I want to address that first, because if everyone agrees that we're actually in motion for summary judgment land, and that's where we are, it's turned around, because usually I hear and see this when, that's where we are. And I want to know if you all have sorted that out, or if we need to now call this something different and see if anyone wants to engage in discovery in connection with a converted motion for summary judgment, even though it's not the movement who is relying on what might be something outside the four corners of the pleadings.
Yes, Your Honor.
First, since
If I could speak to that for the defendants I represent, Kronos Resources and Mr. Smith, we did note in our reply brief that there were matters being raised outside of the complaint itself, which is not something you can do at the motion to dismiss phase where you look solely to the complaint. That is something we would oppose. And I don't believe the court needs to look outside of the complaint itself, because the plaintiff has a remedy, and the court actually has a way to address those kind of issues, which is through an amended complaint. If the plaintiff thought that it was necessary to bring up issues that they wanted to have taken as true, they could have amended their complaint and said, we didn't discover this until this date in this fashion. So I think that would have been the appropriate way to do it, which has not been done. We do oppose having this determined on evidence, because we have not submitted evidence. And if we go down that road, I think the parties would want discovery and affidavits and transcripts, and it's a whole different procedural posture. But I think the court can still rule today regardless, because under the case law cited in our motion to dismiss and in our reply brief, when there's a claim that fraud has told the statute of limitations, which is what I understand the purpose is of the plaintiff submitting the deposition transcript of Ian Smith that was taken back on August 8th of 2023, is to try to say they didn't learn of facts that put them on notice of their alleged fraud until that August 8, 2023 date, but there's a burden on the plaintiff to show in a non-subjective fashion and an objective manner that they could not have discovered the fraud earlier. And I haven't seen anything fleshed out in the arguments submitted by the plaintiff that I believe establishes they could not have determined this earlier. And to the contrary, I believe their argument is actually that the original authorization in the form of a court order that allowed the initial foreclosure sale was induced by a fraud. And I think that can be resolved on a legal determination without going into tolling anyway, simply because there was no representation in that original proceeding or that order to the plaintiff. I think what they're essentially alleging is a fraud on the world type of theory. And I believe that they drop a footnote, maybe footnote 1 in their response to a case that they indicate supports this argument that a public filing, if you will, something can establish fraud, that people could rely on a public filing for fraud. And they cite the case BPP 069 LLC versus Linfield Holdings, which was a Georgia Court of Appeals case from 2018. But that Linfield Holdings case actually said in it that the plaintiff in that case was not entitled to rely on the document in the public record. That had been the plaintiff's contention that they could rely on it, and the Court of Appeals rejected that. That case had to do with zoning of a real property. The buyer of the property thought that there had been fraud with regard to representations about the zoning. The Court of Appeals said a misrepresentation as to a matter of law can never be the basis for a charge of fraud because everyone's charged with knowing what the law is. You can determine it for yourself. And the court went on to say zoning is a legislative function of a county, whether land has been zoned, and if so, the uses that can be made of the land under applicable zoning or ordinances. So it's a matter of law and therefore cannot be the basis for a fraud action. And I think it's a similar outcome here where we don't even need to reach the tolling question or the deposition transcript, because if the claim is from the plaintiff that the underlying process of obtaining the order authorizing the initial foreclosure was induced by fraud, it was not a fraud as to the plaintiff. They were not a party to that case, so they were not told anything in that case. They were relying on a court order that said a foreclosure could occur, and the foreclosure did in fact occur. No one showed up after the fact and claimed a superior interest in the property. So in terms of the process, the process was authorized, was valid, went forward and was not disturbed. And I don't think the court needs to even reach the evidence. So we do object to the evidence being reached, and we think legally the court doesn't need to reach that evidence for that reason.
If I choose to reach it, what is it you want me to do? If I say the Smith deposition is out there, and I'm going to consider it in assessing whether there was fraud when things are told, or however I'm going to rely on it. I understand you're objecting to it, but if I decide that it is appropriate and necessary for me to rely on your client's deposition, tell me what relief you would seek.
Yeah, and Your Honor, I think if the court were to put in an order, I have considered the deposition, the court could easily follow that up by saying, but I don't find the testimony to be controlling on the issue of concealment or tolling, because under the objective standard that's required, and we cite the case in our motion to dismiss of Jim Walter Corp., which was a 1980 Supreme Court case, Georgia Supreme Court case. Under that case, the standard to determine tolling is objective. It's not whether the plaintiff believes they did not discover it until it first came up, or they couldn't have discovered it any quicker. The court must determine, could they have discovered it any quicker? And what the case law indicates is with regard to matters of law, matters of public record, everyone has the same amount of notice immediately and all the time. So you're not entitled to wait on someone else or to rely on someone else. And what they're telling us essentially, they believe the initial order that authorized the foreclosure sale was invalid, that you could not sell a common element of a condominium. So that order, the court was either induced through some fraud to allow that to go forward when it shouldn't have, or it was just wrong. But everyone has to make their own determination of whether they could purchase a property under the law. They can't rely on someone else, even the court, to tell them that, and especially not when they're not a party to that case. And again, no one disturbed that ruling. The ruling went forward, but nothing frustrated them. I think the real issue in terms of could they have determined this was a common element earlier.
But you're missing, it's not about whether it was a common element. That's what I started this whole conversation with, that I assume that's what everyone's fighting about, but it's not. That's not what Mr. Huffman has pled. He said it's not the common element piece, because I think you have a good response to that. Due diligence could have revealed that 5F is a common element. What I'm understanding, and I was given a fairish grade on this, that the fraud and the trickery and the whatnot was these alleged shenanigans where Clark swoops in and says, well, we're going to do this and we redeem and this and that, but money doesn't change hands. And I'll tell you the way it looks on paper is that Kronos says, dang, we own something that's worth nothing. Let's see if we can flip this in a foreclosure. And if we do, then I need you, Clark, to slide the money across to me so that I'm not out $111,000 because I bought something maybe I meant to buy it because I got a bigger scheme in mind. Maybe I bought it and I hadn't done my due diligence and didn't realize that 5F is not what it seems on paper. But the plaintiff's not saying we're frustrated. They are frustrated that they got sold a common element, but it's fair to push back saying anyone who was interested in making that purchase could have first said, but what is 5F? Show me some pictures. Oh, look, it's a storage closet or it's a little square on a common patio. That's not what they're saying. They are focusing on some money shenanigans where money ought to have flowed in a direction and it didn't. And the only way they learned about it was through your client's deposition that occurred many years later. And I don't accept your position that that was knowable before then, unless you knew to take a deposition of Ian Smith. And at a deeper level, I'm pushing back a little bit on the notion that if, as pled, there were these money shenanigans that really made some of the transactions that were ultimately affirmed by this court, but weren't made clear to this court, that the court's blessing on them doesn't make them suddenly clean and non-fraudulent. I think that's what we're here to discuss.
Right.
So please don't talk about whether 5F was a common element or not anymore, because that's not, the FPC loses on that one in terms of the statute of limitations having run.
Right. Well,
Your Honor,
Your Honor, that's
correct.
just to make sure our argument's understood. That is not our argument. Our argument is they are presenting as their position that the fraud was in the initial process. They're saying that the whole process was tainted because there was some misrepresentation to the court. But what I'm saying is the misrepresentation they're alleging is simply one that authorized a sale of something they've contended could not be sold. Otherwise, there's no fraud at all. If it could be sold, what are we here complaining about? So
okay, well, I've heard you say that now a couple times. So Mr. Huffman's going to pop if he doesn't get to talk. But before we get to him, Mr. Davis, is there anything that Mr. Roble didn't say that you want to say about me considering the Smith deposition? That's all I want to hear about right now.
Yes, Your Honor. Just briefly, footnote 2 of our reply brief, there's discussion about how we believe that the deposition testimony itself may not actually be admissible even for a motion for summary judgment stage on the grounds that the deposition obviously wasn't taken in this case. And so under OCGA 24-8-804B1, deposition testimony is excluded by the hearsay rule unless the person trying to proffer it demonstrates that the declarant is unavailable. I don't think Mr. Roble would say that Mr. Smith is unavailable.
Well, I will tell you this, you're newer to the case. Mr. Smith was unavailable for a long, long time. That was a man who was very hard to track down. And you and Mr. Roble are at a bit of a disadvantage in that you don't have the same history with this case that I do. But getting information about Mr. Smith from Mr. Clark, you would think we said, well, where's Jimmy Hoffa? But apparently Mr. Smith is alive and well and deposable, but that was not an easy process. So it's not, I wouldn't be so glib as to say, oh, Mr. Smith, he's just let me know. I'll make him available. That was not how he was playing this game.
Well, thank you, Your Honor, for providing that history for me. But from my client's perspective, it's still on the party trying to utilize the deposition to demonstrate that in the pleadings in some way, shape, or form. And we don't believe that the plaintiff has met the burden as to that. And then just quickly, as just to the misrepresentations, one of the main arguments we have is regarding the fact that the misrepresentations, according to the complaint, were specifically found within the foreclosure suit. And as we described in the anti-SLAPP defense, any statement of law included in that complaint regarding whether or not the redemption sale was proper or anything like that, as Mr. Rebel mentioned before, really cannot be relied upon because you're presumed to know the law. So we believe that even with or accurately defining what exactly the fraudulent statements are alleged to be, not the actual Unit F being occupiable, but this redemption deed happening, still we believe our motion to dismiss should be granted, even if you consider those statements.
Okay, I'm going to turn to Mr. Huffman. Before I do that, Mr. Davis, your microphone's not working real well. You were sort of going in and out. So you should take a look at that. Mr. Huffman, one, relying on the Smith deposition, and then two, there were a couple points where Mr. Roble was saying things and you started waving your arms around. So I'm happy to hear you on those.
Thank you, Judge. I thought we were getting a little off topic as to what your question was, which is.
We did.
Yeah, and so basically the anti-SLAPP is what allows you to consider the deposition, period. We don't have to convert it to an MSJ. We object to being converted to an MSJ. We would seek discovery before an MSJ is hearing. I think we have to have notice of it since we're the non-movement, even if the court was to convert it before it could hear it as an MSJ.
Well, but that's why I said it was I don't disagree with what you just said about notice, but what's peculiar about it is that it's not the movement who's saying, hey, you should dismiss this case because see the Smith depot. It's the person opposing dismissal who's saying, look at this thing that's not in the record, which is why I brought this up at the very beginning, because that's not normally how it happens. It's the party seeking to dismiss saying, hey, look, and here's this other thing, and you should dismiss it. So talk to me about why anti-SLAPP allows consideration of the Smith deposition.
Because anti-SLAPP requires evidence. To rebut an anti-SLAPP requires evidence. And the Smith deposition is not hearsay, it's a party admission. So the hearsay rules don't even apply. We're not even close to hearsay. So it's a party admission. And the court can take judicial notice of the previous record, which is where the other facts are coming for anti-SLAPP purposes. So that's where we are. All of it should be considered. I mean, I don't know that you really need a lot of the facts in order to determine the motion to dismiss. From our perspective, as far as the transcript is concerned, they're all pled. The general allegations are pled, but there they are. So that's my answer to the procedural question.
Okay. Thank you all for that. So I'm going to let Mr. Davis and Mr. Roble decide how they want to move forward as the movements. All I'd ask is that you not cover the same ground. So I don't know how you want to divide it up. I have had a chance to process the motions as to each of the counts, RICO and fraud and conversion, et cetera. I'm a little confused, but this is more for Mr. Huffman about whether the unjust enrichment is actually money had and received instead, but that has less to do with is it dismissible as opposed to nomenclature. The counsel for defendants have the floor, however they want to divide the floor.
Yeah, Your Honor, for Kronos and Mr. Smith, I'm happy to work through the arguments and see if I've covered things before the other defendants, the Clark defendants, join in, if the court's willing to have us proceed in that fashion. That's fine. I mean, again, it's the two of you. You have arm wrestled in advance or you haven't. You raised your hand first, so you can go. All right. Thank you, Your Honor. At the heart of the complaint, as the plaintiff has recharacterized it essentially in its response to my client's motion to dismiss, is the argument that plaintiff, quote, seeks compensation for the fraud which allowed the foreclosure sale to have taken place at all, end quote. That's from the response to the motion to dismiss at page 2 of the response. So they're going back to the initial authorization of the foreclosure sale, claiming that is the fraud. They double down on that at page 4 of their response when the plaintiff states, quote, the fraud alleged in this case began when the Clark defendants, Kronos and Smith, conspired to record a deed. So that's really how they characterize their complaint in a nutshell, is the authorization of all of this, which goes back more than 6 years ago, was the fraud. And I think that is a direct tie-in to our first argument on the fraud claim, the common law fraud claim, which is the first substantive count of the complaint, and as to why common law fraud must be dismissed, because nothing alleged in the complaint as characterized by the plaintiff itself in its response is a representation to the plaintiff. The plaintiff was not a party to that case. There was no document issued to the plaintiff as a result of that case.
How does that work though I try to think things more simply, because this whole tax sale and redemption and it is an area of the law. I'd be fine if we exported that to Alabama, but it's here. Let's say I run a used car dealership and I have a car on my lot and big neon letters, mint condition on the windshield. And I know it's not, but I put that on there. And it doesn't say, hey, Mr. Roble, mint condition. It just says mint condition. And pick your words, whatever it is, I want you to rely on it, and it's false, and I know it's false, and I try to sell you that car. How is that different from this? How would I, as that car dealer, somehow be immune from a suit for some type of fraud if I sold the car and it was a lemon and not in mint condition? But it looked like it was in mint condition, and some basic due diligence, poking around. I had reset the odometer to 1,000, all that kind of stuff. And you roll away. But I didn't design that for you. I don't care what sucker buys that car. This is for anyone I can lure. Is that person who bought the car unable to sue me because that was to all the world?
So there is a whole body of law around that exact scenario, Judge, which is the law that a fraud claim cannot be premised upon what's considered by the courts as puffing. And something like mint condition is a classic example.
So bad example. Let's just say it says 1,000 miles on the windshield. I put 1,000 miles, and I've messed with the odometer, so it says 1,000 miles. And you buy it, and that's not puffing. That's a lie. It's not 1,000 miles. I reversed the odometer, and I've defrauded you, and you drive away. But I didn't say, hey, Mike Roble, 1,000 miles. I don't, like I said, I don't care who buys this car. I made a bunch of money. I bought it for 200. I sold it for 1,000. I'm a happy, crooked used car dealer. Can you not sue me?
Well, you might have a suit in that case because that's a misrepresentation of fact. The case law that we are relying on in our motion to dismiss indicates that what you receive when there's an order that says a foreclosure is authorized is not a statement of fact, it's a statement of law.
Right, but if the foreclosure authorization order signed by me was premised on false information given to me, then why isn't there fraud perpetrated on anyone who relied on that court order?
Well, I would contend you can't have fraud with regard to any kind of legal position, meaning what the law is. If someone said to the court wrongly, Judge, this is authorized as a matter of law and it should go forward, and the court issued an order saying that's authorized as a matter of law, that does not let another party say, I don't have to do any of my own due diligence in determining whether I can buy this property. But more to the point, Your Honor, there was nothing that was relied on in that order. What that order established was that the sale could occur, and the sale did occur. No one has disturbed the sale by saying they have a superior claim of title to that property. So there's simply not a fraudulent representation arising out of what the plaintiff claims the fraud is. They're essentially saying there was some fraud behind the scenes they didn't know about, which proves in itself they didn't rely on it. if they did not know about it, there's not something they relied on that would have been fraud, and there's no statement of fact to them. You know, it would have been, if we had put in the order, Unit 5F is a habitable unit of the Springfield condominiums or Springside Park condominiums, that's a totally different issue. But that's not in the order. It just authorized the sale. The sale took place. They got the property through the sale.
Okay.
So with regard to common law fraud, that's our position as to why that should be dismissed.
Okay, got it.
The next claim in the complaint's essentially, in my mind, an extension of the fraud claim, recasting fraud under a RICO type of framework. That, in fact, I believe was the portion of the plaintiff's response brief that said that the fraud here began when they all conspired to record a deed, because that's how they get to RICO. They're saying there were multiple participants in a fraud. Therefore, it turns into a RICO conspiracy.
So one of the arguments, I can't remember if you made it or Mr. Davis and his colleagues made it, was, hey, it can't be a civil RICO unless there are multiple transactions, and here there's only one transaction. And then Mr. Huffman said, yeah, if you're talking about RICO law 20 years ago, but here we are now, and that's not the state of RICO law now, that it doesn't require multiple transactions. There may need to be two or more, I call them overt acts from my time as a prosecutor, but concrete steps that you're taking, but it can involve a single transaction. Who's right on that?
I think that Mr. Huffman has the better end of the law on that one in terms of the number of transactions, the number of steps. Our position on the RICO claim is that there is not an underlying fraud. So you can't have any underlying overt act if there's no underlying fraud. But secondarily, that the statute of limitations has passed, because what they're telling us in their response brief was the conspiracy was more than 6 years ago. And the RICO statute indicates a claim has to be brought within 5 years after the purported conduct terminated, which would have terminated with the authorization of the sale, the way they're explaining it. And that was more than 6 years ago, because the court entered the order authorizing the sale in January of 2018.
How long this case has been bothering me.
Yes, Your Honor. But for those two reasons, because there's not an overt act if there's no fraud, and the court order was more than 5 years ago, we contend the RICO claim is not viable.
Okay.
Additionally, Your Honor, the common law frame would be barred by the statute of limitations. Apart from our position, there was no representation to the plaintiffs. This again goes back to when the court authorized that order well over 6 years ago. I think their response to that gets into tolling. And our position on tolling is essentially that there was nothing that they learned later that they couldn't have learned prior to that time. And the law on tolling puts a burden to show that there was active concealment, essentially, that some sort of step by the defendant is what prevented the plaintiff from learning of the fraud, which the way they characterize the fraud, there's nothing that prevents them from learning of it because there's nothing they relied on. They're claiming the fraud is something that they knew nothing about at the time. I don't see how that can be fraud. It goes to this whole theory of what their fraud is, essentially, that the order could be fraud. They knew as much about the order the day it was issued as they know about the order today, which is that it authorized the sale. There's nothing further that makes that fraudulent or non-fraudulent, because again, it's not a representation of fact, which the Court of Appeals has said many times. You can't premise fraud on opinion. You can't premise fraud on future predictions. You can't premise it on a statement of the law. It has to be a statement of fact. And there's no statement of fact, so there's nothing that they could have discovered earlier or later. The order was issued when the order was issued. I mean, and although Your Honor's already talked with us about this, I think what they're really complaining about is they bought a common element, an uninhabitable element, which they could have known back then. If they went to the condo and said, show me Unit 5F, or talk to an owner, talk to the HOA, talk to the seller, I mean, they could have done due diligence on that.
Okay.
Your Honor, next we have the fraudulent transfer claim. The fraudulent transfer claim by the plaintiff arises under the Uniform Fraudulent Transfer or Avoidable Conveyance Act. That act essentially is for instances where a creditor, typically a lender, shows that there's been a fraudulent transfer.
You don't need to, I'm going to let Mr. Huffman, when it's his turn, try to salvage this one. But to me, this is square peg, round hole. I follow you on this. I mean, you and I see these in a situation where you owe a whole lot of money to someone else and you slide your house over to your wife, so I can't go after your house.
Right.
And I'm going to let Mr. Huffman articulate how ISBC was a debtor to FPC, but you don't need to cover it anymore.
Then I'll move on to the plaintiff's conversion claim. There are two reasons, Your Honor, that I don't think the conversion claim is viable. The first is that money is not a subject for a civil action for conversion, unless it's something like rare coins that are identifiable coins. It has to be an identifiable fund, a discrete source of money. Once this money was paid over and left Mr. Clark's trust account, it was as fungible as any money in the world. So that'd be the first reason. The second reason, which I don't think the plaintiff responded to in its response to the motion to dismiss, is the statute of limitations. A claim for conversion is subject to a 4-year limitation period. The conversion would have been the foreclosure sale date when they acquired the property and paid the money over, the date the money left, which was March 6, 2018. Of course, even after tolling for COVID, they were beyond a 4-year period when they didn't file this case until September 30th, 2024. Similarly, with regard to the unjust enrichment claim, the statute of limitations on an unjust enrichment claim is also 4 years and would have arisen at the same time. They're saying when the money went to the other parties, they were unjustly enriched. So that's barred because it's well past 4 years by the time they file this on September 30th, 2024. We've both touched on the anti-SLAPP arguments a little bit, Your Honor. That's a two-part analysis. The first part is simply, is the type of claim being made within the scope of the anti-SLAPP statute? We cite case law indicating that what's in pleadings, what's put in complaints, that sort of thing is protected by the anti-SLAPP law. I think that's a prima facie showing that then triggers the court moving to the second phase. The second phase is the plaintiff then has the burden of proof to show a likelihood of prevailing on its claims. So the plaintiff has that burden in terms of who's going to establish that they're likely to succeed on the merits of these claims. And I think a lot of this does take us into our other arguments, which show why those other claims are barred. But I just want to note for the court, the real issue there is that it's the plaintiff's burden when you're in an anti-SLAPP context to make that showing.
Right. It's the evidence and hence the deposition.
And I think, Your Honor, that Mr. Huffman's correct that in an anti-SLAPP context, you can present evidence. So I don't think it's barred in that sense. That what I would object to the court determining as a matter of summary judgment when we have not responded with evidence.
Certainly would not. I hear you. And I hear Mr. Huffman saying don't go to that space either because he'd want to do more discovery. So, and I don't intend to convert anything. I just wanted to hear from the three lawyers their thoughts on the use to which I could permissibly put the Smith deposition. And it's been helpful to hear those three perspectives.
Next, Your Honor, we raised an argument that the plaintiff's claims are barred by the statute of limitations in Georgia Code Section 91160. This really gets into how the court's going to characterize this. It seems in a lot of respects like what the plaintiff is doing is asking to relitigate a previously determined matter where the court issued an order in January of 2018 authorizing the sale. And we believe when you step through the analysis under 91160, they either had to do that within 3 months or 3 years of when that order was issued in January of 2018. Both of those time periods have, of course, passed. So there cannot be a direct challenge to the 2018 order at this point. And if there cannot be a direct challenge to the 2018 order, I think we're left with that order being a valid order authorizing the sale, which again, we conclude means as a matter of law, there cannot be a viable fraud claim. Finally, Your Honor, with regard to civil conspiracy, punitive damages, and attorney's fees, those are all what we would call derivative claims. They
Right.
exist only if one of the other claims succeeds. So for that reason, we believe civil conspiracy punitives and attorney's fee claims should also fail. And if I've left out any material issues, I would take it that's something I didn't cover that Mr. Davis could still add to, Your Honor, which I'd love to have him do.
Got it. And I will turn back to both of you once Mr. Huffman is done so that the movements get the final word. So, Mr. Davis, what do you want to add to what Mr. Roble just shared?
Yes, Your Honor. I think Mr. Ribble did an excellent job summarizing the opinions of these defendants as to these issues. Just some minor little things. As to the conversion claim, from my recollection in the plaintiff's response brief, they talked about, actually, Judge, you should take it form over substance. It's not necessarily a conversion claim, but rather that it's actually a theft by deception civil claim. Georgia Court of Appeals has already ruled on that issue in McCalla-Raymer, LLC versus Foxfire Acres, Inc. It's a 2020 case that essentially said that the theft by deception criminal statute can't support a private cause of action. So if the court wants to, it's up to the court's interpretation if they want to review it as a conversion claim or this theft by deception civil claim. But if you see it as a theft by deception civil claim, that should be dismissed as a matter of law. And as to the unjust enrichment claim, again, from my recollection, plaintiff said, again, form over substance. Actually, this is really just like a fraud claim, but we're wanting to plead unjust enrichment as an alternative theory. Now, in Cash versus LG Electronics, Inc., it's a 2017 case. Court of Appeals said you cannot plead unjust enrichment as an alternative in a tort action, but you can in a contract action. And of course, there's no breach of contract claim that we would argue for all the reasons brought up, but including this one, that the unjust enrichment claim should be dismissed. Otherwise, I just saved my time for rebuttal that Mr. Huffman could present his take.
Okay, we'll just finish writing this note down and then we'll turn to Mr. Huffman.
Oh, and one more quick point, Judge. I apologize. For the actual RICO claim, as you know very well, that it requires two predicate acts, like two criminal actions to be viable. We submit that one, by the heightened pleading standards, the theft by deception portion of the predicate offense hasn't been pled correctly. But then also theft by receiving, at least as to the Clark defendants, there was no receiving of stolen property. Plaintiff provided my clients the property to hold an IOLTA account and then transfer it over. So at that time, we would argue, of course, the court can determine it as well, but that wasn't stolen property at that time. And then the only other property that my client could have held was the $500 that were alleged. So just wanted to get that on the record as well.
Got it. Thank you. Okay, Mr. Huffman.
Thank you, Judge. Let me start with some of the facts, and you have categorized it generally accurately that what we are seeking. So, and I'll run through some of these because I know you're familiar with it and have lived through this saga. So, when they buy this unit that turns out not to actually be a unit,
They meaning your client?
No, I apologize. They being Kronos through Ian Smith.
Okay.
When they buy this originally, which is August of 2017, they buy the unit from a tax sale themselves for $110,000. On the very exact same day they buy it. Okay, so Ian Smith and through Kronos buy it. The very same day, John Clark, as an authorized person, that's the title, authorized person for this entity called Southern National Assets, executes an assignment of a lien to ISBC. Okay, now to this day there is no record of what this lien was. It was a non-recordable lien. But the very same day that they buy it, Kronos and Smith John Clark executes this assignment to ISBC. Okay. And so then 30 days later, John Clark prepares the deed, the quitclaim deed of redemption. And Smith, on behalf of Kronos, signs it, saying in it a false statement. It's a crime that they had redeemed the lien. That ISBC had paid Kronos $133,000. It's a 20% fee. And Your Honor, just to back up, and I realize this tax deed law is weird, but when a lien holder, when you sell the tax deed, you have a year to redeem. A lien holder has the right to redeem as well as the owner. When they do so, they're granted a super lien at that point to immediately foreclose. So you can short circuit the year-long process, and this is what a lot of tax deed investors do. If it's done legitimately, it's legal. They go find a lien, but in this case, there's no record of this lien that they bought, and they've now admitted under oath that they never actually paid the money. Okay, so they filed a deed saying it was so, and they all knew at the time that it was false. So this is a crime. This is a fraud. They were not entitled to the super lien. They were not entitled for the property to revest in the original owner.
Which was it. So that's where I get lost in a lot of these twists and turns with this tax deed stuff. But from whom did Kronos buy 5F, or that doesn't matter because you're saying original owner is Kronos?
He bought it from the tax commissioner, and it doesn't really matter.
Okay, so original owner means Kronos for our analysis.
Yes.
Okay.
Well,
no.
I'm sorry. It was the condominium association owned the unit, and it got sold by the sheriff to Kronos. So
okay.
when it's redeemed, it goes back into this entity that's like an HOA. That's not really important. What is important is that by the false deed, ISBC gets the super lien, purportedly. That's what they allege. That's the fraud in the whole thing. And so, had they not lied about that, they wouldn't have had a super lien. Then they come into court.
And the way they got the super lien was through this unrecorded lien at the very same day Kronos bought 5F from the tax commissioner. He assigns this lien, Mr. Clark, to ISBC, and then they use that lien to pay off Kronos so that the property kicks back to the condo association, and that triggers the foreclosure sale.
Correct.
And then your client comes in saying, great, let's buy this, thinking that there had been, in fact, a legitimate redemption with a legitimate super lien, et cetera.
Right.
Okay. So, assume for a minute that everything you described happened with all of the pejorative adjectives as well. Hold on one second. Thank you. No problem. Appreciate it. What's your response to, and I'm pulling us a little bit away from your presentation, and I appreciate the presentation. Mr. Robles, one of his many points is, okay, I don't think he says assume all that's true, but I'm saying assume all that's true, and there's this nefariousness. In the end, that's invisible. Well, not in the end, but at the time, that's invisible to FPC. And they come in thinking, hey, we are interested in buying 5F, and we buy 5F. If 5F had actually been an occupiable unit, what your client thought it would be, et cetera, we wouldn't be here. Isn't the fraud that this is really all about is that 5F wasn't an occupiable unit, but no one ever said it was, and people didn't do their homework, and they had buyer's remorse. And so now they've been digging around to find out, well, maybe there was something untoward that happened prior to the foreclosure sale.
I think that was certainly fraud too. The fact that it was not a real property, but
but that's not what you're litigating now. You agree that that's got some statute of limitations issues.
Right. And I mean, and the truth is, Judge, we already have a judgment against ISBC who did the foreclosure sale, and we can't collect it because of all this fraudulent behavior and everything else that's going on with Mr. Clark representing them unauthorized and everything in that case. And so,
Yep.
I mean, the reality is, I mean, just like you were sort of drawing a hypothetical, fraudsters go out and mass market fraud all the time. I mean, I'll take any idiot that I can steal money from. It doesn't matter. I mean, this happens in practically every fraud and every Ponzi scheme. So, I mean, the fact that, going back to your car analogy, that, well, golly, you bought that with a bad odometer, but the truth is I don't really have title to it either because I already sold it to Paul. I sold it to Paul 2 months ago. And so I lied to you about that too. I mean, it doesn't get you off the hook just because, well, maybe if I had known about the odometer as well, then I wouldn't have done it. And I mean, to the extent that that could even be a valid defense, I mean, I'd love to hear that in front of a jury.
No, I don't think some of these are jury arguments. What's the detrimental reliance, though, for your client in connection with, and this may get to some of the arguments that Mr. Davis and Mr. Roble make about what that's like to all the world. How did your client detrimentally rely on, really did the money flow from ISBC to Kronos before the foreclosure as opposed to afterwards?
But they relied that they were dealing with honest people who had a piece of property.
Well, but see, now you're bleeding over into the part about a piece of property. And I know it's difficult to separate it. And if I were that gentleman who was on the screen every time we had hearings back when it was FPC versus ISBC, that's where it would be top of mind, is that you guys tried to sell me something that didn't exist. But you have, in response to these motions to dismiss, you have repeatedly characterized the fraud and the conspiracy and all that to be a foreclosure sale. I mean, there's the piece where the money slides across finally to make Smith whole afterwards, but it's the representations that were made to the court that everything had occurred that has to happen to allow the super lien to be in place and the foreclosure to occur. And you've helped me understand, assuming the allegations to be true, that they didn't happen. And so maybe a fraud was perpetrated on the court. I don't know if the court was harmed, but never a good idea to tell the court something that's not true. But how did FPC detrimentally rely on that when in fact the foreclosure sale went through? No one later on swooped in saying, but I'm Pete and he sold me the car first, so I get the car. None of that happened. It was simply, to Mr. Roble's point, dang, 5F isn't what we thought, which may well also be a fraud, but that's not the fraud you've claimed you're fussing about anymore, probably because that would run you into some statute of limitations issues.
Because they bought it. The answer is because they bought it. They put money out to buy it. That's it. They relied upon it all because they bought it. So, I mean, just like you'd buy the car. I mean, and again, like ISBC was the entity that sold the property, right? But Clark and Smith are the ones doing all the fraud and criminal activity behind the scenes to make the sale occur. There's already a judgment against ISBC, right? So you're kind of conflating the parties to sort of bleed it over into the title issue with ISBC. They bought the property based upon all the representations that were made to the court and to the public and the deeds and the records and the foreclosure advertisements. And they put out $133,500. So that's how they were harmed by relying upon those statements.
Got it.
So let me go back to a few more facts here, and then I will go through these legal arguments because they are relevant to the argument. So once
before you do that, let me do one thing. Hold on.
Yes.
All right, I'm back. Thank you, Mr. Huffman.
Okay, thank you. So, so going back in time, so my client buys the property and then discovers, of course, that it's not an actual piece of real property, files a lawsuit against ISBC, and then something remarkable happens. John Clark defends the case from February of 2020 through April of 24. So over 4 years, John Clark files an answer. He files a motion to dismiss. He reinstates ISBC, okay, as an active LLC. He opposes my client's motion for summary judgment, and he appeals it up to the Court of Appeals and loses. And he does all of this without authority and without talking to ISBC.
Who is ISBC, Mike? Who will he be talking to unless ISBC is Mr. Clark or is Mr. Smith?
You nailed it, Judge, because that's exactly what we think.
So then how is it without authority? If he is ISBC, how is he doing it without authority?
But he said to you in open court that he, quote, "I've never spoken to anybody at ISBC as it relates to this case." We think that it's likely ISBC is Ian Smith. I mean, you know, ISBC, Ian Smith, and I'll get to what we believe the BC gets to in a second. But he represents this entity for 4 years. He changes law firms from Clark Cassie. He starts his own firm. There's no engagement letter. There's no transfer letter. There's no records. He never talks to him. He has no contact information for this guy named Charles Vitton, who's allegedly who's allegedly the member of ISBC. This guy is a ghost. We have no idea where he is. And so, you know, during this post-judgment, so I mean, who does this? I mean, we have all sorts of illegality going on with the 4 years of this representation. I mean, what is happening? I mean, I've never been involved in a case where a lawyer stands up and says, you know, for 4 years and through an appeal, I never talked to my client, not one time.
Okay, but we're here on the motion to dismiss, so stay focused.
Okay, so, and we do have a 915-14 I want to remind you about on that case.
Okay.
Okay, so then during the post-judgment, of course, we have Ian Smith under deposition, and we ask him if he got the money. He said unequivocally no. And then he goes on to say he knew that it was false when he signed it. He considered withdrawing the deed later. He even thought about suing Clark for malpractice, but he did none of that at all in the case. And so the only other transaction that ISBC was ever involved in was a loan that they made against a property owned by Ian Smith, where Smith indicated in his deposition that that loan made it harder for a bankruptcy case, EC, to get the property back. That is the only other transaction. The only thing this entity has ever done is deal with John Clark and Ian Smith. That is it. And what this is a gigantic criminal fraud. All right. So number one, I think, and you can tell me if I missed one of these. Number one, they argued that the fraud was not a representative of the plaintiff. I think I've talked about that. I mean, these are facts. He argued some about an opinion or something. I mean, whether or not the redemption price was paid is a fact. When you put it in a deed and say it's happened, and then you later say in a deposition it didn't, that's a fact. It's false.
But what about the argument that this is my slight spin on it, but okay, maybe there were some misrepresentations or things that were below board as opposed to above board that are going on between Kronos and ISBC and Clark and Smith. But in the end, there is this legal document / order from a court saying, yep, there's a proper redemption and the foreclosures can go forward, et cetera. How do you get around the kind of anti-SLAPP perspective that you can't be seeking to You can't sue people or seek damages from people when it is representations that are made in legal pleadings.
So, okay, so going to the anti-SLAPP,
I didn't mean to, I thought that's sort of where you were headed was anti-SLAPP. If you were going somewhere else, just as long as you get to anti-SLAPP.
I mean, I can go there now. Just give me 1 second here to shift gears in my mind, at least. First of all, the deed is not within anti-SLAPP territory, period. And neither is the foreclosure ad. And
The foreclosure application?
the foreclosure ad. The ad.
Ad. Okay.
Yes, sir. The one that ran in the paper, misrepresenting ownership and lien holder status. And the misrepresentations to the court are not, they're crimes. I mean, so you can't say that we're somehow immune to crimes because they're crimes and we put them in a plea. I mean, it doesn't work like that. I mean, as you know, as a former prosecutor, so like you don't get to, that's not there's no immunity as to criminal activity. I mean, RICO covers perjury and other things that happen within court proceedings that would otherwise be, privileged. I mean, perjury being a good one, a good example of another privilege. And so, all right, so that's the anti-SLAPP. I just want to say, going back real quick to the representation of the plaintiff issue, that was not argued initially. They put it in the reply brief. That several of these arguments they made, they didn't put in the initial motion. You can't bring an argument in your reply brief to sort of renew it. But they argued about the facts. Okay, so the statute of limitations issue, let me talk about that for a second. I mean, this applies to every single claim.
Right.
We cited it. You don't have to, there's no nuance to this between the different claims. We cite the case. It's a very pithy quote. That's one of the cases say the sun never sets on fraud. I mean, it's told. My client states in the complaint, he discovered it August 8th, 2023, which was the deposition of Ian Smith. That's when all of this was discovered. There's absolutely no way, and you said this earlier, we'd have to have bank statements or depositions that were truthful in order to have discovered this. We would have sued for it in the last case if we had known about it. I mean, we had no idea until we started doing post-judgment discovery, and it's like, oh, guess what? None of these entities are real, and we've transferred all the money around. So regarding RICO, I think they're arguing that there's some sort of strict pleading standards. That's just false. Unless you allege fraud as a predicate act, there's no higher pleading standards. That's not Georgia law. And citing federal cases for Georgia RICO is a very good place to miscite the law, because federal RICO is much tighter and as are federal pleading standards than Georgia pleading standards and RICO. So it's just not true. But to the extent that you find some of the pleadings deficient on any of these issues, we can amend. That is the remedy. But I don't think any of that's necessary at this point. Okay, we talked about the single transaction. I think I don't need to talk about that. Well, let me talk about the fraudulent transfer. You put that on my list to talk about. So we become a creditor as defined by the Fraudulent Transfer or Uniform Voidable Transfer Act now, is defined as anyone with a claim, whether it's unliquidated, whether it's contingent, whether it's fixed or not. It can be in contract or tort or anything else. The moment we paid the money and were defrauded, that's the moment we became a creditor. And that is absolutely the law in every situation, because this happens all the time. Somebody defrauds somebody to start with, and then later they have fraudulent voidable transfers that occur. And it relates back to the time you were defrauded, not when you get a judgment. So it has no relevance. The judgment against ISBC. The moment we were defrauded by Clark and Smith and their entities, we became a creditor, and the statute of limitations was told until we discovered it. At that point, we had a claim that ripened against them when we discovered it, and had the applicable statute of limitations, which I believe is 4 years, to bring it under that act. And the fact that it's not liquidated yet is irrelevant. You can bring a avoidable transfer action in the same case as the underlying action.
But what are so then remind me what the fraudulent conveyances are. You pay for it, the money goes into the Smith's escrow account, and then, not Smith's, into Clark's escrow account, and then he pays it out to Smith or Kronos or both. The fraudulent conveyance would be from the escrow account to the person from whom your client purchased the. I'm just trying to see what the sneaky transaction was. I don't need to be sneaky, but the money just went where everyone knew it was going to go. And it wasn't to conceal it or anything like that.
No, it should have gone to ISBC because they were the lien holder that auctioned the property off. Instead, it went into John Clark's trust account and he transferred it to Kronos.
Okay.
It had already represented that they had been paid. So now we can't collect from ISBC because ISBC never got any money. And so it went into their account, and any action taken by a transferor or a transferee to hinder, delay, or defraud a creditor is avoidable transfer, period. And there is a whole statutory scheme with intent and badges of fraud, and there's a whole statutory scheme that doesn't require intent. And so at this point, under the standard that we have of sort of like, can you find evidence to support it, and a motion to dismiss, clearly the evidence is there to support the fraudulent transfer action moving forward. And just to clarify, it's 9/11/18B that allows you to bring avoidable transfer or fraudulent transfer action in the same case as the, like a tort or breach of contract or whatever the actual case is. They don't have to be separate.
Okay.
I'm not sure they really argued that, but just for clarity's sake. The argument under 9/11/60 is a little bit perplexing to me because we're not trying to set aside that order. And I mean, it's already been set aside. You already ordered it set aside. So I don't really understand that argument at all. I mean, that was ISBC's judgment. ISBC is not a party here. And so I don't really understand that argument at all. The conversion issue, this money should have gone into the IOLTA account for Mr. Clark, and then it should have gone to ISBC. It didn't. And that is money that was held for a specific purpose, which is what they argued is the standard. And that money should have gone to ISBC. Also, I mean, it's my understanding you can sue civilly for theft in any sort of situation. So call it whatever we want, whatever the nomenclature we want to have, conversion or theft by deception. But if you steal from me, I can always bring a civil case, which is exactly what we've alleged here. All the other, sort of contingent claims are covered in there. And then the unjust enrichment claim, my memory is they only argued in their motions that we didn't plead it sufficiently and that there was a statute of limitations problem. I think in their replies, they try to raise another argument, which we'd object to. I'm not exactly sure what their argument is here today, but it is sort of a...
Well, the argument was it's barred by the statute of limitations, only 4 years. And we've already gone back and forth about, well, was the fraud uncovered or should have been uncovered the day of the purchase when people should have known 5F wasn't really a meaningful piece of property, or it was when Smith was deposed. So we don't need to talk about that. And then there is an argument about the the defendant to unjust enrichment occurs when a defendant allegedly induces or encourages a plaintiff to do something with an expectation that the defendant will cover its costs. And so it's really that it just doesn't quite fit in this situation. And it may have been that's to which you responded, well, anyway, that I understand your perspective on it and the defense perspective.
All right. I think unless you have any other question for me, I think I covered their arguments. I will yield the floor back.
Okay.
Your Honor, I do have very brief rebuttal on a few of those points. And just want to note initially, there was a very long recitation by plaintiff's counsel of what sound like factual assertions in this case. Most of those were not in the complaint, and most of those were not in the deposition transcript. So I don't think most of those are things the court takes as true presently. There were a lot of claims of wrongdoing, stuff going on behind the scenes unknown to them that they later found out.
It was a great opening statement, but I will worry not, Mr. Roble. I will be governed by what is in the complaint and not what may have been articulated today.
And I think a lot of those, even if taken as true, are in the same bucket as what is in the complaint, by which I mean they're things that were not relied upon by the plaintiff, therefore could not have been the basis for fraud. They were not factual representations to the plaintiff. There was no reliance. And this is all because the plaintiff freely admits they didn't know any of that at the time. When they bought Unit 5F, they were unaware of all that, so they could not have relied on that.
Well, I got to press you on that a little bit. What I'm hearing Mr. Huffman say is that the FPC relied on there having been a valid redemption of the tax lien, and I'm sure I'm using the wrong terms, but you get my point, that the process that's supposed to have happened really did happen, so that the foreclosure that was happening was in fact one that, while it was authorized by a court order, that court order was premised on truth rather than fraud. And Mr. Huffman is saying it wasn't. It was premised on fraud. And there, in fact, that foreclosure sale was problematic because ISBC was not, in fact, the right party in that mix because the money hadn't changed hands, et cetera, which was why it was important, I think, for Mr. Huffman to detail, here's what happened at this time, and money didn't flow here and it did there. And assuming those statements are also in the complaint, those are things I could rely on. Assuming them true, do we have an issue? So I guess I don't follow you when you say they couldn't have known it, so they didn't rely on it. But they, in fact, did rely on these things being accurate and true and valid, and they weren't. And that's the fraud.
And Your Honor, as he was saying that, I was writing down in my notes, number one, what was the representation? Because it's got to be a representation of fact. And just the common law definition of fraud is the defendant makes a material misrepresentation of fact that's relied on by the plaintiff to its detriment. And so I keep asking and keep writing down, what was the specific representation that they claimed they relied on that's a fact that injured them? Because again, the sale happened. It's not like the condo association is coming to the plaintiff saying, give us back that common element, you can't have it.
Right.
No one's trying to disturb their purchase. That's not what's at issue in this case. They're saying something they didn't know about was a fraud on them. And I just don't see how at the end of the day, something you don't know about is a fraud. And their example proves our case. When plaintiff's counsel says a Ponzi scheme is a great example of a fraud on the world, a Ponzi scheme by definition is when the proponent of the fraud says, I've got this great business, come invest in it, you get high returns, and there's no business at all. The payments to the initial investors come from the money of the later investors. So there's a false statement of fact that they have a great business when there is no business. In contrast, we've got this fraud on the world theory that you don't have to point to the misrepresentation. And that is not the law of fraud. You've got to absolutely have a misrepresentation of fact and to show how you relied on it. And I think where the plaintiff's counsel started to get closer to that, he actually a couple of times said they relied on things like the foreclosure ad.
Right. So that's what I was going to ask you about. There's the quitclaim deed and the foreclosure ads, which are not things that a court said. Those are, as Mr. Huffman characterized them, facts. I mean, they may be legal documents, but they exist outside a piece of litigation. They're part of this litigation, but simply because they've been made part of the litigation doesn't immunize them from criminality.
Yeah, and all that they say, if you read a foreclosure ad, is there's going to be a sale on a certain date at a certain time at a certain location by a certain party and describes the property. All of that happened. The sale went forward on the first Tuesday of March of 2018 at the 10 o'clock to 4 o'clock time period when it's allowed on the courthouse steps. I mean, everything in that ad was 100% true, and that's where they got title. So there's no misrepresentation identified by the plaintiff in any of those documents that they could say, this is something that's false, where I was injured by that specific false thing. That's what the key thing is, probable or not probable. The key thing is you got to have the actual harm. You've got to have it tied to the actual misrepresentation, which is what we're missing here, is what was the misrepresentation they relied on that harmed them. So I think we're right back where we started in terms of missing the fundamental basis of the fraud in this case. Additionally, Your Honor, the plaintiff says they didn't discover the fraud until August 8, 2023, when they took Mr. Smith's deposition. They still have not identified what that fraud was that they discovered, unless they're saying it's this behind the scenes dealing, that things they didn't know about, that they didn't rely on, therefore, were later revealed to them. So again, it's the same sort of theory. With regard to the Uniform Voidable Transfer Act, I take it to be the plaintiff's position that the statute didn't run because that kind of transfer is told until discovery. And I've not seen any case law cited by the plaintiff that tolling applies to that statute. That's not a common law fraud claim. That's a creature of the legislature, that you can undo certain transfers or get a claim for money for certain transfers. And what the money that's transferred, they're saying it was the money they paid to John Clark, which they knew at the time they bought the property in 2018, they had paid John Clark. So they knew back then that there had been a transfer that took place. There's no reason to toll a claim for that transfer that would come all the way to 2025. With regard to both the conversion claim and the unjust enrichment claim, I didn't hear anything that I believe undoes our argument about a 4-year statute of limitations period. The plaintiff's counsel said you can always sue for theft. You always have a civil claim for theft. Not after the statute of limitation runs. It's a 4-year statute of limitations. You don't always have a claim. That's exactly what we're saying, that the law has said as a matter of public policy, there comes a time you just close the book on it. If you haven't filed your suit before then, you can't file your suit. And obviously, there are a lot of public policy reasons for that, but that is the law. Your Honor, I think that's really where we are on this, is the statute of limitations bars these claims because of how long ago they took place, and there's not evidence of tolling. What really took place was they were unaware of things that they could not therefore have relied on, could not have been damaged by, and for that reason they should be barred currently, and that's why we're asking the court to dismiss these claims.
What if, what's your response to a scenario where I buy something and it has all the trappings of having been legitimate and safe and by the books, and it turns out that it wasn't, that there were misrepresentations about how it was built or how it was put together? I end up not being harmed directly by that. Fortunately, there's no accident that it says it can withstand. It's a step stool and it can withstand 200 pounds, but it really can't. But I only put 180 on it, it doesn't break or something. But I later on learned that someone's been selling these stools and you can't put 200 pounds on them or they'll break, but that's what they say. So I wasn't harmed. I got the stool. It's not what I thought it would be. That's still fraudulent to say, don't worry, this is this thing, i.e. this is a foreclosure that ought to be able to go forward because ISBC redeemed this from Kronos and all these things have happened, when in fact they didn't happen. But the foreclosure goes through, no one swoops in, like you said, the condo association coming in, or Paul with the automobile example saying, well, actually, you sold it to me first, so I'm going to take it. So there isn't ultimately that harm. But had I known what really went into this, I wouldn't have made the purchase because it had some vulnerability you didn't tell me about. You failed to disclose it. In fact, you actively deceived the court and thus anyone who were to take a look at it, that all of the redemption process had occurred as it is supposed to statutorily. Because that's the allegation, is that they didn't do the things they were supposed to. You make a compelling argument of, I'm simplifying it down to 2 words, so what? Because the foreclosure happened and you got what you paid for. You don't like 5F, but the fact that 5F isn't an occupiable unit has nothing to do directly. It may be why there were these shenanigans and Clark is selling this lien and this and that the day of Kronos's purchase. But in the end, 5F was saleable, 5F was purchased, and the technical defects in that redemption process that may have been procured through fraud on the court and thus fraud to the general public wanting to rely on the court order, they didn't end up harming directly FPC. But isn't a consumer, a purchaser, able to say, well, you know, I wouldn't have done this if I had known about all these things, which I only discovered in the end, which is how I got my judgment saying, ISBC, you need to disgorge this stuff. And so here we are saying, well, we're going to go deeper because it turns out ISBC doesn't really even exist. And we now know where the money went. And we want it back from these people who were involved in this shady dealing in creating the foreclosure opportunity to begin with. I don't need you to agree with any of my facts. You know, this is sort of assuming Huffman's tale is true. Isn't there still a fraud claim?
I don't believe so, Your Honor. And fraud claims are always very factually specific. That's why we've got all these different bodies of case law that have to do with very narrow areas like future opinions. You know, it could be a future opinion as to profits, where someone says, I was told I get a 10% profit and I got 1%. Courts have said that's not fraud. Future predictions can't be fraud. Or the advertising puffing, or there are all these different areas, super factually specific. And, you know, going to the step stool example, that's another example of why facts are really, really important for fraud claims. In that example, Your Honor, there's a sticker on the step stool, as I understand it, that says it'll hold 200 pounds. That's a specific factual representation. You can determine with an engineer or with a material scientist that it won't hold 200 pounds. So you can
but consumers don't normally do that. I don't think I'd be barred from suing the step stool manufacturer if I bought it and maybe this is sort of the stuff of class actions. I wasn't injured, but I did buy one of those, and that's dangerous. And there probably was a way that someone could have figured out that there was something funky about the process leading up to the foreclosure sale that resulted in FPC acquiring 5F. Bring in your engineers, bring in your person who does a deep dive and realizes, wait, money didn't go here, it went there. And you might need subpoenas to do that. But in the ordinary course, a diligent purchaser doesn't do all that stuff. And we don't fault them for failing to do all that. But then the light is shined on it, and lo and behold, that step stool wouldn't hold 200 pounds. And this foreclosure transaction, fortunately, it ended up being okay and no one swooped in, but it wasn't done by the books. And yet the parties represented to a court and thus the public, it was done by the books.
Right. But Your Honor, if you take the example of the class action, which typically those arise under consumer protection statutes. So they're authorized by a specific authority. If you just had a single plaintiff who bought a step stool and said, it didn't collapse on me, when I get on it, nothing happens, I'm fine with it, I don't think you've got the damage element to bring a fraud claim. You've got to have the damage element.
Okay. And I think that's your point. I mean, that's what I'm hearing is it may well have been these things that didn't happen the right way, but the real damage that FPC claims and has is 5F isn't what we thought it was. And now later on, they are, I'm not saying they're manufacturing. It sounds like there was some funny business about even getting to the foreclosure point. But those other things that we're hearing about, that maybe the money wasn't transferred at the right time, and what is ISBC and this and that, those created no harm to FPC because the foreclosure sale went through. It was never attacked or anything like that. The harm was an investment into something that turned out not to be what people thought it was.
Correct. And that is the damage component. You've got to have the damage component. Without that, there's no basis for the final element of the common law fraud claim. Your Honor, you also touched on was concealing things fraud, but concealment has been held over and over again to only constitute actionable fraud when there is a duty based on a fiduciary relationship, such as if you're a trustee or if you're holding the party's property or something, then you can't conceal something you're doing. So they can't rely on concealment because they were not someone in a fiduciary relationship with the seller. So I think all we've got is a common law claim where the elements are your classic factual misrepresentation, reliance on a specific fact, and damage tied to that actual reliance. It's a thread that runs from start to finish, and that just doesn't exist here.
Got it.
Which I don't know. I've done all the talking on the reply. I don't know if Mr. Davis had anything.
No. He has time as well. It doesn't work that way. I will hear from him if there's something he wants to add.
Yeah, Your Honor, go ahead, Mr. Rubble.
No, that was it. I was finished.
Thank you, Your Honor. Just a few things. Number one, for the fraud tolling statute to apply, you've got to show three things. One, or allege three things for it to work. One, the defendant committed an actual fraud. Two, that the fraud concealed the cause of action from the plaintiff, such that the plaintiff couldn't bring the action. And that third, the plaintiff exercised reasonable diligence to discover the cause. We've kind of been going around this, but again, we're on a motion to dismiss, not a motion for summary judgment. Plaintiff needed to allege facts to show reasonable diligence. So for that and all the other reasons that Mr. Roble brought up, we don't believe that plaintiff pled reasonable diligence to allow the fraud tolling statute to apply. Going to Mr. Huffman's response about the RICO claim about not needing a heightened particularity standard, I turned the court to the attention of the case Bazemore versus U.S. Bank National Association, 363 Georgia App, 723. It's a Court of Appeal case from 2022. And it talks about how the Bazemores had alleged 4 predicate acts that they claimed constituted a racketeering activity. And one of those was for theft by deception. And the court found that the plaintiff didn't plead it with the requisite degree of particularity. And that's what we were arguing as to the heightened pleading standard for the RICO claim. And then also, of course, I know Ms. Rubble already objected to the factual open quotations colloquy about allegations that weren't in the complaint. Of course, the Clark defendants also would object to you considering anything that's outside the 4 corners of the complaint. And then, of course, again, hold the opinion that you shouldn't consider the deposition, but of course, the court can make that ruling as appropriate. Otherwise, Your Honor, I think Ms. Rubble handled things pretty well, and I will be done.
All right. Roble gets the Davis seal of approval. Mr. Huffman, I know you weren't the movement. Is there a 15-second thing you just got to say before we wrap up and let Ms. Brooks go on her way?
No, I'm good, Judge. Thank you.
You're good. Okay. I appreciate everyone's time. I particularly appreciate you shifting your schedules around because we had to get the late start. This is lots for me to work with. I reserve the right to reach out to say, give me your thoughts about X as I wrestle with a particular point. I also reserve the right to say, hey, I'd like you to draft this. The other side would have a chance to review what was drafted, not change the outcome, but say, well, wait a minute, we think it should reflect it this way or that way. But I will make sure that I keep moving this along. Mr. Huffman, anything else on behalf of FPC Deed?
Yes, Your Honor. I just want to remind the court that discovery, unlike a normal motion to dismiss, I believe the parties have taken the position that discovery stayed because of the anti-slap component. I just wanted to remind you of that in lieu of sort of timing on the order. Most cases, we'd be able to move forward on discovery while you're preparing the order, but in this case, because of that, unless you order us to open, which we'd love for you to do, but.
So you agree that because anti-SLAPP has been pled in the motion to dismiss, discovery is stayed. It's not just that 90-day one. If the motion to dismiss were filed contemporaneously with the answer, but it's until I rule. But you're not opposed to saying let's do some discovery.
We would prefer to open it up so it doesn't. I mean, you're known to have prompt orders, and we've always appreciated that. But I know sometimes it gets busy, and I don't want to sit around and it's the end of the summer before we can open discovery. So,
got it. Wow, I'm glad I'm known for that.
To the extent you find like one claim to go forward, you could sort of open discovery.
Got it.
Forward. So,
okay, Mr. Roble, do you have a perspective on discovery?
Yes, Your Honor, I'd be concerned about starting it unless we know which claims, if any, are going forward, because we may spend a lot of time and money on discovery that we don't need to spend, depending on, I mean, ideally, obviously for the defendants, no claims go forward, no discoveries needed, but even if it was just one claim, the scope on one claim could be totally different than another. Like if the fraud claims are barred, those may have intensive facts, take tons of depositions, tons of documents, whereas if unjust enrichment's not barred, that may be super simple, just a matter of how much money did you get and was it unjust? So we don't really know what we're doing discovery on or how much time and money to spend until we have the ruling.
Got it. Okay. Mr. Davis?
As the same as Mr. Roble suggested, essentially.
Okay. All right. Well, I will keep you guys posted if it looks like this is falling lower on the priority list of things to get out. We can revisit discovery, or if it's clear that I decide claim A and C survive, I'm not sure about the others, I'm wrestling with it, there may be a way to do some targeted discovery in connection with those. They're all kind of interconnected. So I think they're, for some of them, if you're doing discovery on one, you're really doing discovery on the others. I will keep all that in mind, and I appreciate your time. You all will make sure Ms. Brooks is taken care of?
Can I just inquire, Mr. Huffman's firm had hired us to be here. Mr. Roble and Mr. Davis, do you want to participate and take down?
Yes, we do.
Okay, very good. Our office will send you a bill then.
Do you have a pleading with our contact information?
I do not. I'm assuming
we can
you're
get
in
it
the
to
Atlanta area.
Yes, yeah, if you
Yes.
Google us, you'll find us, or it may be on something the plaintiff has, they've sent you.
Okay, that'd be perfect.
Okay, thank you.
Thank you so much.
All right. Thanks, everyone.
Thank you,
Judge.
Your Honor.
Thank you, Judge.